The following conversation is not legal advice. Please consult your own legal team if you have any questions.
Previously, where you might have a privacy penalty capped at $2 million, there are now concepts of looking at 3 times the value or sometimes 30% of turnover.
Joining me today is Phil O'Sullivan, partner at the commercial law firm Allens. He's one of the leading voices on privacy and regulation in the healthcare space. This is a critical question because we know most life sciences are looking at this. If you don't have that medical legal representation being the clinician, where do you see the red line being drawn?
If you have a technology that is designed and aimed at patients, taking out the healthcare practitioner and having the technology stand and face the patient consumer, they are the red line areas, I think.
What's a misconception around privacy regulation?
The biggest one I would say is that there's not always that comfortable, clear, green light, no problem answer.
It all sounds quite scary because you're essentially saying that whatever you do, you always have a level of risk because the letter is not black and white.
Don't be scared.
I am scared, by the way you describe it, but I'm always scared when I hear a lawyer talk, so. Hello, I'm Roman Bonchin, CEO of RosaRx, and this is Future Pharma. On this podcast series, we will explore the fast-moving evolution of life sciences, technology, and the evolving patient and HCP experience. I'll be talking to industry leaders who are looking forward and understand the challenge and opportunities that lies ahead. Joining me today is Phil O'Sullivan, partner at the commercial law firm Allens, specializing in technology, regulatory, privacy, and data law. Phil, thank you for sitting down with me.
Thank you. Thank you for having me.
Phil, there's one question I like to ask all our guests as to start the show is what excites you in the future of healthcare?
In my area of practice, what I see, there is massive investment in health technology data right now. There's some really big trends in the sector. So some of those trends are driving that investment and focusing the investment. So some of those trends are more personalised healthcare, more of a focus on preventative healthcare, and artificial intelligence in healthcare is part of that in terms of trying to support or assist clinical decision-making, automate some tasks for efficiency across healthcare organisations. So seeing quite a lot of activity. Some of this has been done for some time. You know, there's use cases of automation and AI in healthcare for a while. Radiology is a good example where that's been done for quite a while and it's reasonably well understood. But there are other segments of healthcare sector where we're really at the outset of trialling that use. And there are other areas in the healthcare sector that are not so obvious candidates. You know, radiology, you have images, a lot of data that lends itself to being able to be automated and able to sort of develop algorithms and use AI. Others now we're seeing more complex development trying to augment or help human skill, judgment and decision-making.
Yeah.
You can't always determine black and white rules around how to take it, what to do with it in every circumstance. There's lots of scope for machine learning. So often it's a case of the technology today and in a year time, in 2 years' time is going to be better. And a lot of times it's about what you're asking it to do early and how you prove up the use case or demonstrate the value, and leaving space once the technology gets better or the data gets better going into it for more complex asks to be made of the solution or the technology and allow it to develop over time. Sometimes we see a lot of goodwill and intent early at trying to get the solution to address everything. And then you can press up against some regulatory barriers or risk use cases and so on. So it can often be the case of trying to simplify the use cases early and bring or demonstrate that evidence base for use in a successful way. And once you have a solid base, then sort of adding more complex tasks.
I'm quite interested in a point that you just made in saying that, and it sounded like advice, that you see a lot of innovation that restrict the amount of ML or AI early on so that it can fit into a regulatory door and then expand after. Yet we've seen again and again that a lot of the aha moment that we see with both structured and unstructured data happens really early when you unleash maximum intelligence on the data sets and enrich it with external data. Historically, those are harder to get compliant because there's a lot of black box issues. What's your advice on those kind of innovative approach?
I think a really big thing to bear in mind from a regulatory perspective is what will your solution do? What are you asking it to do? And also, what are you saying to the outside world it will do and it will achieve? Because you can sometimes come up against a regulatory barrier because of the functionality of the solution. Mm-hmm. Other times you can come up against that barrier because of the way that you're promoting the solution. So when there's a lot on the table and a lot of potential use cases, oftentimes that can mean that you are sometimes unsure of exactly what you're expecting to get out as an output mm-hmm. and how you will make use of that. And right now in healthcare, there's a risk-based approach to regulation. So higher risk use cases attract more scrutiny. They will attract more regulatory issues. That requires really deliberate use cases and pre-planning. So it's often the case that you have to know exactly what you're asking of the solution and what you expect the technology to deliver before using it to make sure you stay on the right side of the regulatory barrier. Mm-hmm. So it could be that you're ready to have a really advanced use case and you've got evidence base to sort of demonstrate that it would be a successful use case, and you understand the regulatory framework you're operating in, and then you go and deploy. But it's more often the case that you actually need to break it down a little bit and think about a staged approach where you say, right now I'm going to ask and I'm going to build the product around these deliberate uses. I'll have planning around some future uses and I'll understand where it could go. But most of the time in healthcare, before you make the quantum leap, you have to make these step-by-step leaps, and you're usually looking for that strong evidence base to warrant making the next step along the path.
In a lot of advanced systems, there's going to be privacy issues. And so you're extremely familiar with the proposed change that the Australian government is making around the Privacy Act and how it relates to patient data. And we all know patient data is the most important tools if we want to have intelligent conversation and assist those areas of innovation that you've mentioned earlier in the show. My question is, what would you advise life science company and healthcare company in general to look for and prepare for changes over the next 2 to 3 years as it applies to the evolution of the Privacy Act in Australia?
Good question. So the big thing in Australia is that we have what they call principles-based legislation. Mm-hmm. So quite often it will not be a black and white answer, written in stone in terms of you are permitted to do this or you must not do this. What we have largely are principles which will govern the use of sensitive information by healthcare companies, but it's quite often up to the organisation to interpret those principles and consider their business use cases and apply them. There are other parts of the world that are more express around what you can and can't do with data. What we have in Australia supporting that is some regulator guidance that's provided from time to time to try and give organisations more of a sense of what the regulator expects will be appropriate uses of data. So what we really have is quite a lot of room to move for organisations to determine how transparent they will be with privacy practices, how they'll take steps to protect personal information, whether information will be held in Australia or go offshore, whether they need to obtain express consent for uses of information, or whether they can use information within an individual's reasonable expectations. Where there's room to move, you can get things right, and you can also get things wrong on occasion. And so what we also have in Australia is a very active regulator, and the regulator has been active in terms of taking action when organisations have fallen short of certain standards around obtaining consent or protecting information. There are a few different cases where that's occurred. We had significant law reform in 2014 to the Privacy Act, And until now, we haven't really had further significant reform. So this is sort of 10 years worth of change in the world that's now coming along and packaged up as privacy reform. And the best way to think about that really is that there have been some early wins and easy wins for the government in terms of things they're bringing into the Privacy Act. So there's more tools available to the regulator around enforcement action and responding to non-compliance by organisations.
Which admittedly was a bit overdue.
A bit overdue.
Yep.
And there are also increased penalties for organisations. Now the regulator can take into account the sort of conduct that an organisation has engaged in and the benefit they obtained through that conduct. So previously, where you might have a privacy penalty capped at $2 million, there are now concepts of looking at 3 times the value the organisation derived from the non-compliant activity, or sometimes 30% of turnover. So they've gone quite high in terms of sending a signal to organisations that if you engage in serious interferences with privacy, the ceiling of possible financial consequence for that action will be quite high. Previously, the regulator thinking would be that if there was a maximum of, say, $2 million for doing the wrong thing, some organisations might be motivated to factor that in as a cost of doing business rather than take the compliant privacy action.
I work in organizations that do both European, American, and Australian privacy consideration, and it does feel the collegiate approach of privacy regulation in Australia is a lot friendlier to an organization trying to find its way than the American model, which is an absolute bridge, first bridge, $5 million fine, and a trip to the FDA. It feels a lot less strict. Am I misunderstanding or misreading it?
Look, I think we have a mature privacy ecosystem in Australia. We have a regulatory setting that allows businesses to make their decisions about the level of transparency and their public-facing documents and how they explain, for example, uses of data across the organisation. It allows businesses to use their judgment to work out how they present themselves to the outside world and how transparent and explainable that is. Most of the regulatory action we see are more in the category of inadvertent non-compliance. So an organisation may have suffered an information security breach and may not have had the best contract with a third party in terms of holding that party to account for protecting information. There will be things like that. It is less common to see cases where organisations have deliberately engaged in activity to ignore individuals' rights to consent to certain uses of information and so on. And I think in Australia right now, if we had that sort of conduct, that would be something that I think the regulator would be compelled to take action on and be very public about taking that action to set an example of that sort of conduct.
That's fair enough. And yet somehow I still find the American system easier because you've got a whole ecosystem and architecture around it. You've got to have BAA, otherwise your insurance or your certification won't work. You have to have regular audit. And it feels as a developer or product developer in healthcare that it's a lot easier to navigate HIPAA compliance or GDPR compliance because of very stated rule and a whole ecosystem of products around it than the Australian privacy. Going back on the question, Phil, what would you recommend pharma, life science company to look at for specifically around the next 3 years, and specifically with this explosion of API-driven interconnections and powerful tools such as LLMs and others?
So what we've had in Australia is tranche 1 that has been put through. In this first tranche that the government brought in terms of Privacy Act reform, there was a statutory tort around an invasion of privacy.
Sorry, I'm going to have to get you to precise that.
I can cover that. So essentially, if there had been serious interference with privacy and an individual had been wronged, they may have grounds to bring a claim directly, personally, in respect of that conduct that was wrongful. That's a new thing and a new development, because before that, if an organisation had mishandled your privacy, you could complain to the Privacy Commissioner, but you would not necessarily have an individual standing to get a direct right of action against an organisation for what's happened. So there's been that in tranche 1. There's consideration in tranche 2 of a separate direct right of action for individuals. So what healthcare organisations might face in the future if a project has gone wrong and individuals have been affected in terms of misuse of patient data, sensitive information, is they could, rather than just answer to the regulator for that activity, face a series of individual claims or potentially class action in terms of the conduct. So there may be, in future reforms, more of a sense of individuals being given more control to take legal action individually in respect of mishandling of patient data than has been the case presently. So it ups the emphasis and the requirement on having governance and practices and preparedness and being on the right side of that reputational balance in terms of not being so sharp on your activity that it could meet a minimum legal threshold but still have people disaffected by the use of information to the point where there are individual claims coming against the organisation.
Feels like lawyers are going to benefit from it after all. So I understand the theoretical approach, and the two trench this idea that an individual can feel wronged, tortured, which I just realized is a French word for wrong. Welcome to legalese. And basically individually sue. So beyond the Privacy Commissioner, legal action could be stemmed from individual wanting compensation, essentially. And that's a high risk. We see this in Europe. We see it in the US. So less academically and more technically, what would be your best advice if you were to face novel or innovative healthcare play that specifically look to harness the latest AI advance? And with that privacy and government trend, that right to sue is understood. But practically, what would be your main advice?
I think the biggest thing is understanding that there is likely to be more regulator scrutiny and activity and focus on these projects gone wrong on occasion. There is an increasing sense of consumer control of their healthcare data in Australia, including where data has been de-identified and is used for a subsequent use. I think, though, in the next 3 years, even though there may be more guidance issued and potentially more regulatory action against organisations, and there will still be this increased sense of consumer control over data, we still operate in a principles-based system. So organisations won't be able to find a clear, express, black and white letter of the law statement about you can do this or you must not do this. It is likely still to be there is room and areas in terms of where you might sit on that scale, for example, in terms of transparency of disclosure about what you'll do with patient data or how you'll protect patient data and keep it safe while you hold it. But you're unlikely to find really clearly expressly stated rules, which could happen elsewhere in the world where you say, you know what, if someone requests to delete their information, we must delete it.
Yeah.
Over here, you take into account whether you have a separate legal obligation to keep data for a certain time or not, whether it's clinically relevant or not. You have to go through a series of processes. So organisations in healthcare should be prepared in the next 3 years to still be applying these principles to take account of regulator action. But they won't necessarily be able to do so with this clear, bright line between right, wrong.
So if I'm a leadership in an organization and I want to really minimize my risk and future-proof myself with the evolution of the Australian Privacy Act. So say I'm a pharma leader in Australia and I want to really minimize while still harnessing innovation. So going back quite tactical, it all sounds quite scary because you're essentially saying that whatever you do, you always have a level of risk in Australia because the letter is not black and white. And if I'm American leader that just came to Australia temporarily, I'll be terrified hearing that, and it'll really restrict my ability to innovate. What would you advise in that context to do in order to really minimize? And I know no lawyers will never say it's black and white, but would offering like a real GDPR-like and bundle consent to users with a privacy officer that's contactable at all times, similar to an adverse event officer. Would that be a first step to really minimize that risk, or you believe that at the end, the way it's designed in Australia, it really stymies innovation because there is no absolute and the risk is always underlying?
Don't be scared.
I am scared by the way you describe it, but I'm always scared when I hear lawyer talk. So
there's no reason not to do this. You know, there's huge investment in healthcare. There's a lot of efficiency. There's a lot of improvement to patient care that can be unlocked through these challenges and using data. But my approach is always, why not engage with this, and why not unpack it and explore what is possible and what it looks like, and how you can sort of come to a new use of data so you don't stay locked in the current state forever. Transparency is really important. So there will be uses of data sometimes. I touched on de-identified data before, where you may not have a legal obligation to obtain the express individual consent from an individual to use data to generate certain insights or to improve technology or products or services. So there can be proper uses of de-identified data where you don't need to expressly obtain individual written consent to that. An organisation will then have the decision about, even though there's not a legal requirement, are there transparency measures? Can I have a web page on my website which talks about some of my de-identified data uses or our emerging uses of AI? Can I explain to the outside world how it's being used? You know, do I understand whether we are supporting clinical decision making? Do I understand whether it's automating a certain task or not? And what am I prepared to say publicly about that to try and assist healthcare consumers sometimes, or healthcare organisations, stakeholders, understand exactly what's happening with the data? And, you know, this idea that everything will stay in a black box and organisations will not disclose what sort of technology used in the business or not, I think you can engage with that and find an appropriate level of transparency and explainability. And if you start there and start to unpack those things, I think that can reduce the risk of individuals being surprised by your data use in an organisation, or surprised that certain data sets have been shared with a third party, for example. Those sorts of things start to then shape the overall risk profile of the organisation. So you can reduce it at a higher level and then sort of engage, what else do we need to do, and what are other parts of that?
From a product developer perspective, we found that Australia is a little bit softer, which is great in a way that you can confidently know that you're not going to get immediately penalized to death if you push the envelope and make some mistakes.
Yep.
But at the same time, it's lacking a very clear code I found that you found in the US with HIPAA. Could you, for the benefit of our listener, give us a quick overlook of what you see the main difference between US HIPAA type privacy approach, Australian Privacy Act, and EU/UK GDPR approach?
Yeah, look, I think structurally looking at the different systems, you're more likely to find certainty in the US and Europe because there is that room to move in Australia and ability to interpret the principles-based approach. Organisations look for certainty, so that can be a point of difference. We have a patchwork of laws in Australia that you need to apply, so it's not just privacy. There's state and territory medical records acts. There's a separate regulatory regime around using software as a medical device. There's a number of different laws that you need to consider and apply with a lot of these use cases in healthcare. But where I think it comes together well and where I think it suits the healthcare sector is that the approach in Australia is still a risk-based approach. So there are more rules and more express standards if you're handling sensitive information like patient data. There are less rules if it is de-identified information, or information that is no longer health information, patient data. And so you do have a tiered approach and you can navigate through that system. In the US and Europe, it's sometimes the case that those distinctions don't apply and you have to follow prescriptive rules, sometimes regardless of whether there's a difference in risk profile of a particular use or not. So I actually think that's an advantage in Australia. From what we can tell from the privacy law reforms, it's an advantage the government seems committed to maintaining. I don't think that will change necessarily, but I think organisations then will look to regulators to offer more detailed guidance about what is considered possible or what's not.
I'm particularly interested in AI-driven engagement. Mm-hmm. So you've mentioned the area of innovation is moving from structured data to unstructured data. And when I look at it from a product realities, we see an explosion of tools to assist clinical decision-making, to assist clinician navigation to recommendations, so decision-making, and also tools to help patient making those steps toward next best action. Some people call it concierging or navigation assistance. We also see the statistics of healthcare usage on tools such as ChatGPT is enormous. I believe it was 35+% of all questions on ChatGPT are related to healthcare. So this pushes me to think what specifically is to look for in the use of LLMs and assistance-driven AI with privacy concerns. What would be your specific recommendation around that?
Data's a great place to start. So often with these models, you need to dig into how that model has been trained and on what data set. So most of the time it will be important and clinically relevant, whether it is a health-specific data set that trained the model or whether it was a general data set that trained the model. Then you need to think about whether that model needs further training with health-specific data or Australian data or segment of population data. And so you definitely want to avoid a view that you can just adopt general tools and put them to use in specific healthcare applications. You need to understand how that model was trained, how it continues to learn and improve, and on what data. And also in doing so, when you're using these tools, are you committing to licensing data or improvements back to the supplier or tool? Just to make sure that if you think you are running a separate instance and all the improvements and learnings are for your individual benefit, and you haven't checked the terms and rules about what sort of benefits flow back, and you have to pair up what is happening with the data flows. Where is it going? Is there permission to share with a third-party tool? Has that tool been properly trained? How is that tool kept up to date? What will the organisation do to have an appropriate level of quality assurance over improvements to that tool over time? So, for example, if you're a solo founder in a healthcare company and there's a clinical decision support tool, what structure do you have in place around validating whether the tool is getting it right or wrong? Do you let clinician users give feedback directly to the tool and learn from that? Do you have someone in the company that moderates the feedback that's given to the tool and agrees or disagrees? Is it the single co-founder of a company that gets to have the say on whether the tool's getting it right or wrong, or is there a panel of clinicians that are providing that sort of consolidated input? So some of those areas need to be explored again as reliance on the tool will increase and as it gets deployed into higher risk use cases.
No, we've seen this curation approach on what data the model gets trained on as being the basic requirements in compliance for life sciences. They're all interested in using it, but they are very, very restrictive and prescriptive about how and which data it is trained on. We've also seen some really powerful use case coming out of it. But most often we find the difficult part from a product perspective is not just so much in the relationship, the RAG, as we call it, but it's in the hallucination component. So absolutely ensuring that the way the data is presented is trained in a way that it doesn't create fake messaging, it doesn't create any hallucination. What advice would you specifically have in product developers, innovators that are using those tools regarding hallucinations and how to minimize it from a legal risk perspective?
There's a really bright regulatory line around supporting clinical decision-making or any element of clinical decision-making. And so it needs to be understood whether this solution is sitting on one side of that regulatory barrier or not. And if you're supporting clinical decision-making, if there are prompts delivered to a clinician, if there's clear accountability that the clinician should consider that as
Advice
prompt or a communication, but ultimately retains full clinical judgment about whether to act on it, whether to raise it with a patient, whether to do nothing about it. If there's no clinician in between the technology and the patient, that's not so clear, I think, in terms of where the accountability or liability will sit, because there will often be times, I think, where a supplier may not be able to completely disclaim or deny liability if the solution was built, if it offered functionality, if it was promoted in a particular way to get to an outcome and it failed. There would be product liability issues arising from having delivered or promised, allowed a patient to use a product in a particular way. Now, it fits into that sort of tiered regulatory system in Australia. So depending on what the product
and
conveys it will do, you may need to get registration, pre-approval, you may need to demonstrate the evidence base. So there are areas that organisations should be filtered into under the current regulatory setting. The key risk, though, is that it is often this patchwork approach. So it requires the organisation to be aware and understand what parts of functionality will trigger parts of the patchwork legislation before they offer to market, before they have users taking up the technology.
Yeah, it's fascinating. I mean, we're not talking about companion diagnostic tool either. We're really talking about navigation and making it a little easier for people. Like you're talking about edge care, talking about, population navigating to, more effective first line, second line, third line treatment. And something that we found multiple life science companies are craving in how can I make it easier for people to understand that there is a solution for better health outcome down here and how to help them navigate. Yet that fear of not having a defined liability is a paradox, because you get this advice on ChatGPT, you get this advice on Gemini using Google with no care or no liability in the world. Yet the moment you start to ensure that you orchestrate the right clinical advice, you trigger a whole series of liabilities. And sorry to be a bit forceful, Phil, but I'm trying to understand where in your legal mind you see the new red line going to happen if we were to transition to the real power of AI that is assisting navigation fully to more and more complex healthcare journey individually for a patient. And I think this is where a real frontier is opening. You talked earlier about the booming edge care, the booming complex patient navigation as being areas of growth. At some stage, for it to really scale, it's going to need to have less human intervention. But if you don't have that medical legal representation being the clinician, where do you see the red line being done and the liability being defined? And this is a critical question because we know most life science are looking at this.
One way to look at it is what is being replaced. So if there is AI or new technology, does it in function or in its promotion replace any element of clinical decision-making? And if you are, then I think you need to think about filling the gap in terms of if there is no medical indemnity insurance, if there is no coverage in that, but either by function or by promotion, you have stepped into that clinical decision-making realm and replaced something, that is a key thing. Now, the Google example, can you prevent someone accessing an open search engine and typing in medical conditions and finding out whether they think they have something or not? No, but also Google's not necessarily being promoted to allow you to arrive at that outcome. If you have a technology that is designed and aimed at patients, health consumers, and it conveys that it will bring some type of benefit to you, either through diagnosis or detection or pointing you towards preventative health measures, you are starting to step into the idea that you are replacing an element of healthcare that they might have got from a healthcare practitioner. And so anytime at a high level, if you can see that step into and replace, taking out the healthcare practitioner and having the technology stand and face the patient consumer, they are the red line areas, I think.
That's a fascinating way to look at it. So when you look at direct-to-consumer healthcare, for example, which has more and more questions and navigations toward a nearly commoditized clinical outcome, like yes, you are eligible for GLP-1, for example, and we've seen those explosions, you believe that the systems look more and more like a clinician and should actually be tested and regulated like a clinician, essentially.
There's this idea of augmenting human capital in healthcare, and that technology would take a place or assist clinicians to do their job or replace some tasks that clinicians don't necessarily need to do all the time. And again, if you're stepping into that space, I think that's where some of the red or orange lines will come up. If it's merely administrative and it's replacing, tasks done by humans at the moment, referral letters, billing, electronic prescribing in certain areas, those sorts of things can be navigated in a way if it's merely replacing, written approval with an electronic approval, those sorts of things. And that's already been navigated by the current regulatory system. But I think the big gap coming up will be, will any provider, supplier of technology or solution be willing to offer something that has an element of taking a human healthcare practitioner out? And if they do so, can they only do so by stepping into the medical indemnity insurance coverage type aspect? Patient demand will drive a lot of that.
Yeah.
So,
but then that becomes in silico medical device.
Yeah.
That's a fascinating frontier. I can't wait to see what comes out of it. So, Phil, earlier you made actually a very human comment, which I liked. You said that fundamentally all of it and all the legislation goes back to being trusted. And trust is hard to get and really easy to lose, as we know in healthcare, and it's quite critical. So what advice would you actually give on innovator in healthcare in how to not so much gain the trust, but retain it in over the next few years as we see more and more data plays and AI play?
This area is all about the above minimum legal compliance mindset. And so investment and understanding in ensuring that there is no bias or discrimination in the technology being used, i.e. that it hasn't only been trained or developed on a certain segment of the population as compared to others, that's going to be really critical in terms of bringing a solution or technology to market that can address challenges in the healthcare system and provide positive patient health outcomes, but do so in a way where there is the element of equal access to healthcare. I think one of the really big concerns in the space is that new technology development might only be available for some and not others, or might not be relevant or suitable. And I think if we're looking at tackling current challenges in the healthcare system and inefficiencies and on occasion uneven health outcomes in the system, any new technology investment and development to maintain that public trust, I think needs to have the element of some sort of equity in access to the new tech. Drug discovery is one of these areas of new AI use. So the idea that rather through the current system of repeated human clinical trials, we could deploy AI to start to predict outcomes and maybe do initial clinical trials on a smaller group of people, maybe avoid the need for a series of ever-expanding trials and use the tech to come to predictive decisions earlier that are still valid and stand up under scrutiny and still have an appropriate evidence base. That is an area where we could ensure equity in terms of what drugs are being discovered and what segments or proportion of the population will they suit, favour and so on. So there's a world here where the new technology use can do a better job than the system we already have.
Okay.
If it can do a better job, I think that's a really critical element of that establishing trust and probably even taking the trust to a higher level than we might have now.
I mean, obviously, this idea we can fast track clinical trial is sits a lot with the regulators as well. But we have seen them change, and we have seen them being quite open, especially as we see enormous efficacy on novel therapeutics, where you start capturing the ethical question of the slower the market entry of that therapeutic, the more actual terrible outcome is happening in real population. So these are very fascinating aspects of how AI could help. But I think a lot of it sits on regulators. And I would actually say a lot of it sits on well-funded regulators, which is starting to be an issue in the United States.
Yes, that's right. Yeah. And look, in Australia, we do have a regulator setting where I think regulators have been more minded to be public about the regulatory action they take, to be noticed about taking action if they think that standards have not been met. And the idea of using test cases to really push a particular principle or a setting or position where they feel like a company or an organisation has clearly done the wrong thing, and that itself and the regulatory action and the consequence attached to it would be a new setting, a new decision for everyone else to notice and then frame their practices accordingly. I think that's been a development in Australia in the last, say, 5 years, where there has been more awareness of the need to be a publicly profiled, active regulator taking serious action when there are clear non-compliances.
Phil, I'm going to hit you with some quick questions. You ready?
Let's go.
What's the biggest industry prediction that you have for 2026?
I think we get more precise regulation. I think we start to tackle this patchwork and maybe even reduce it to bring organisations more certainty about which rules apply and when. Over time, less guessing about whether they're caught by certain regulatory frameworks or not. I think there'll be positive regulatory development to try and assist in that clarity in Australia.
What industry challenges keep you up at night?
The cyber threats in healthcare are really significant. So with new technology adoption, new AI uses, new uses of data, healthcare is clearly one of the biggest targets of all the sectors out there. And so preparedness for that cyber event, the ability to respond, is something that we're helping our clients a lot with in terms of being able to be ready for those challenges, be able to be resilient operationally and stand up and face into some of those challenges. But when they happen, they're really significant in healthcare because of the urgency of care, the criticality of care. These are organisations that often cannot afford to take themselves offline for weeks or months while they solve the IT issues. So there's an element where business has to be continued. It's critical for it to be continued to try and stand up if there were these sort of challenges that came up. So that's a really critical issue when it comes to some of our clients and organisations to tackle. It's clearly high stress, high stakes, responsiveness, and that's probably the worry at nighttime area at the moment.
What's a misconception that pharma and healthcare company often have around privacy regulation?
The biggest one I would say is that there will be a black and white answer for a particular use case or a new project and so on. And so as a lawyer, we spend a lot of time talking and walking through the interpretation and the available options. But ultimately you end up on a scale of activity and you take into account business reputation and risk tolerance and approach, and you factor all of that in. But the biggest misconception will be for a particular use case or stated project that you would be able to land on one clear permitted outcome or one clear prohibited outcome. It's more likely in this space that you will have a scale of options and paths, and then you need to factor in the really important commercial elements, some high-level strategic direction, sometimes from boards and directors as well, to try and navigate through the next challenges. But there's not always that comfortable, clear, green light, no problem answer. It is green with some parameters, with some conditions, and also making sure that from that point, you make really deliberate uses of information around the project. You don't slip into accidental uses because someone has got excited about a new technology and gone down a path that other parts of the organisation weren't aware of.
For pharma leaders, what is the one blind spot they're likely to have when it comes down to using AI?
I think it really comes back to the need for the organisation to be in a position to explain the AI use and the technology. So the explainability of it, including the benefits that flow from that activity, and benefits broadly, not just to the organisation, but to health ecosystem, better patient outcomes, all of those to be understood and then able to be communicated in a way where all stakeholders can see the value or benefit to be obtained from the activity or the improvement or the innovation, rather than just staying focused in a silo of maybe individual organisational benefit.
Phil, I found this conversation fascinating. It can look like a very dry subject, but the trends and the demand, especially post-COVID, on individual wanting more from their digital interaction. And you see that in the usage of GPTs and Anthropic and the fascination for understanding their own health journey. The flip side of that decor, essentially, what's behind the screen is exactly those questions. What is tolerated, able to go and foster investment for further development, and how to minimize the risk on this investment so that it can be built, and what consumers demand can be put to market. So I found these conversations really fascinating. Thanks, Phil. Thanks for joining Future Pharma. Where can people find you?
You can Google Phil O'Sullivan-Allens. I'll pop right up. I'm on LinkedIn, and my number will be on the website too. So like any good lawyer, I'll always answer the phone.
Terrific. Future Pharma is brought to you by RosaRx. The future of healthcare lies in truly personalized patient and HCP journeys, and conversations like this one help us get there faster. Until next time, I'm Roman Bonjin. Thanks for listening.